Hello everybody, welcome to iExamB's Legal B. This is Amrita, your law faculty at iExamB. This is video from the series Judiciary Mains answer writing that has been started at Legal B exclusively. इस सीरीज में हम लोग एक मॉडल आंसर डिस्कस करते हैं दैट इज़ वेरी हेल्पफुल फॉर मेंस आंसर राइटिंग एग्जाम्स फॉर जुडिशरी. इसमें आपके कंसेप्ट भी रिवाइज होते हैं, डिफरेंट टॉपिक्स आते हैं आपके आंखों के सामने, आप कंसेप्ट्स को पढ़ते हैं, केस लॉस को पढ़ते हैं एंड किस तरीके से आंसर्स को लिखना है ये भी आपको अच्छे से समझ में आता है. यू कैन ऑल्सो डाउनलोड द PPTs ऑफ दीज वीडियोज़ एंड गेट ऑल द मॉडल आंसर्स एज अ रिकॉर्ड विद यू. So don't forget to subscribe to Legal B and stay updated with all such kind of beneficial content that we keep on providing you here at Legal B. And if you have any queries, you can write to us in the comment section of this video straight away. You can also write to us at hello@iexamb.com. You can call on this number and visit our website www.iexamb.com for more details. आज की इस वीडियो में हम लोग क्वेश्चन नंबर 8 डिस्कस करने वाले हैं फ्रॉम दिस सीरीज. And that is, what is the basic principle in deciding amendment application filed by plaintiff? At which stage such an application can be allowed by the court? Amendment of pleadings एक बहुत ही important area है and इस area की काफ़ी यूटिलिटी प्रैक्टिस में भी है एंड इसके अलावा इस टॉपिक पर मेंस आंसर आपको किस तरीके से लिखना है ये हम लोग इसमें डिस्कस करेंगे. इस पर कंटेंट किस तरीके का अवेलेबल है उस पर भी बहुत डिपेंड करता है कि आपको आंसर फ्रेमिंग किस तरीके से करनी है. कुछ टॉपिक्स पर काफ़ी सारा कंटेंट ऑलरेडी अवेलेबल होता है डोमेन में एंड कुछ टॉपिक्स पर कम कंटेंट होता है, तो उसे एलैबोरेट कैसे करना है, ऑल दीज थिंग्स आर वेरी इंपॉर्टेंट. So starting with the answer, the general rule of pleadings is that all the material facts and necessary particulars must be stated in the pleadings and decision cannot be based on the grounds outside the pleadings. But many a times the parties may find it necessary to amend his pleadings before or during trial of the case. First thing has been made clear here only in the introduction itself that amendment can be made during the trial of the case or before the trial of the case. It can be made at both the times. And यहाँ पर कोर्ट का काफ़ी सारा discretion होता है. Always try to remember this thing. And it depends that what are the material facts that are necessary for the pleadings that you need to amend it. If you are able to justify yourself that you need to amend it, without that there will be a substantial change in the questions that are there for settlement in the dispute in the matter, then that will something which will be allowed by the court eventually. Order 6, Rule 17 of CPC deals with amendment of pleadings by either party in a suit. Both the parties can do that in their respective pleadings. Plaintiff can do in plaint, written statement can be done by the defendant. What is the exact provision you need to quote over here? It is very important. Amendment of pleadings Rule 17 में deal किया गया है. Order 6 is the order relating to fundamental rules of all the pleadings are covered away. The court may at any stage of the proceedings allow either party to alter or amend his pleadings. So this has been made very clear over here that court can allow this at any stage of the proceedings and it is the discretion of the court. ये भी may शब्द से यहाँ पर clear हो जाता है. So हमारे question का ये part भी clear हो जाता है that where can be the amendment, at what stage the amendment application can be allowed by the court or it can be moved before the court. In such a manner it can be amended and on such terms as may be just, and all such amendments shall be made as be necessary for the purpose of determining the real questions in controversy between the parties. That means it should be something that is really affecting the matter or the dispute between the parties. It is going to determine the real question that is in controversy in the between the parties. Then only it should be permitted to be amended. There is a proviso clause as well, which is very important. Provided that no application for amendment shall be allowed after the trial has commenced. That means after the trial has commenced it cannot be allowed, but unless the court comes to a conclusion that in spite of due diligence the party could not have raised the matter before the commencement of the trial. अब ये प्रोविजो क्लॉज काफ़ी सारा ट्विस्ट लाता है इस प्रोविजन में कि आप अमेंडमेंट एप्लीकेशन ट्रायल कमेंस होने के बाद फाइल नहीं कर सकते. इफ़ यू आर फाइलिंग इट देन द कोर्ट शुड बी satisfied that in spite of due diligence you have taken the due care and you were quite vigilant, but still you could not raise the matter before the commencement of the trial, and that was the only reason. The court is satisfied, again court is having discretion over here. Next part of the answer will be concluding somewhat from the first one. कनेक्टिविटी बहुत इंपॉर्टेंट होती है इन आंसर्स में, ऑलवेज ट्राई टू रिमेंबर दैट। अगर आप कोई पार्ट से दूसरे टॉपिक पर शिफ्ट कर रहे हैं या फिर आप कोई केस लॉ ऐड कर रहे हैं तो कनेक्टिविटी और फ्लो मेंटेन होना चाहिए आंसर में। पहले हमने इंट्रोडक्शन से स्टार्ट किया, देन वी हैव पुट द इम्पॉर्टेंट प्रोविजन, दैट इज द रेलिवेंट प्रोविजन, रूल 17। As it is evident from the provision that pleadings of parties in a suit may be allowed to be amended, which may be necessary for determining the real question of controversy, unless it does not cause prejudice to the other side. ये भी एक important point है कि दूसरे साइड को prejudice नहीं होना चाहिए, तो amendment application grant करने में as such कोई harm नहीं है. In the case of Punjab National Bank versus Indian Bank AR 2003, what was held? An amendment would generally not be disallowed except where a time-barred claim is sought to be introduced. There too, it would be one of the factors for considering, or where it changes the nature of the suit itself, or it is malified, or some other party cannot be placed in the same position the plaintiff had originally filed correctly. That is to say, the other side has lost right of a valid defense by subsequent amendment. यानी कि जब भी आप अमेंडमेंट फाइल करते हैं उसमें दूसरी पार्टी के राइट्स को प्रेजुडिस नहीं होना चाहिए. दिस शुड बी वेरी वेरी कीनली चेक्ड बाय द कोर्ट. और ये पंजाब नेशनल बैंक का जजमेंट यहाँ पर बहुत रेलेवेंट है. Relevant case laws पता होना, that is a part of how deeply you are able to cover the concepts and study for your exam. And उस समय आपको वो एग्ज़ाम के वक्त स्ट्राइक होना भी ज़रूरी है. सो उसके लिए आपको ज़्यादा से ज़्यादा पढ़ना होगा. ट्राई टू इंक्लूड केस लॉज इन योर मेन्स आंसर्स, बट दैट इज़ वेरी वेरी इंपॉर्टेंट पार्ट. उस पर काफ़ी मार्क्स आप स्कोर कर सकते हैं. Therefore, we can consider the main points for consideration कि इस केस में क्या क्या रीजंस थे, ये भी हम देखेंगे. हम यहाँ पे ऐड करेंगे कि क्यों एप्लीकेशन अलाउ नहीं किया गया, and what are the main points that need to be considered. Firstly, the amendment is necessary for determination of real question in the controversy, and secondly, the amendment can be allowed only when it is not causing any injustice or prejudice to the other side. So these are the most important points that need to be considered when an amendment application is being allowed by the court. I would say this is the core crux of your answer. So इसको इसमें points में देना बहुत ज़रूरी है, because when the examiner is going through your answers, all the important points should be very catchy for him to understand. तो अगर आप ऐसे point format में देंगे तो it will become easy for him and it won't be missed by him while he's checking the answers. Descriptive answers है, so ये सारी चीज़ें भी बहुत important होती है. और you can underline it as well. इस तरीके से आप यहाँ पर तो मैं bold कर सकती हूँ, but when you are writing it you can underline it with the pencil. Leave to amend will be refused when the amendment is not necessary for purpose of determining the real questions in controversy, when it is inconsistent case or changes the fundamental character of the case itself. फंडामेंटल कैरेक्टर केस का ही बदल दे रहा है अगर वो अमेंडमेंट, तो ऑब्वियसली वो रिजेक्ट हो जाएगा. or else it is taking away the legal right which is accruing in favor of the other party, then also it won't be allowed because it is with malified intention. यहाँ पर एक और एक एस्पेक्ट अराइज होता है, that is relating to the time limit. Many times for playing delay tactics, amendment applications are moved just to kill the time of the court and keep the applications pending for a long time. So that's why prescribed time limit has been given in Order 6 Rule 18, that if the party is failing to amend even after the amendment order has been passed, there is a stringent time limit of 14 days. 14 days from the date of order, the party has to carry out the amendment compulsorily. और ये भी एक important provision है जो यहाँ पर must है कि आपको add करना ही है. So the provision of Order 6 Rule 17, one more point over here is that Amendment Act 2002 has added that proviso clause, and that proviso clause is also having a similar kind of objective only. That's why I've taken that point over here. That is relating to the time. Salem Advocates Bar Association case, Tamil Nadu versus Union of India case 2005. These cases also talk on the point of this only, that the Honorable Supreme Court has held that the object of adding the proviso is also to prevent frivolous applications which are filed to delay the trial. So ये वाला aspect भी एक बहुत important है amendment से related, which you have to cover over here. And if you are able to add such cases, then it's well and good. The last point which I would like to add over here relating to amendment is that amendment to proceedings is not a right, rather it is a discretion of the court. ऐसे कुछ ancillary चीज़ें भी आपको आपके answers में add करनी चाहिए that are relating to your topic. and it is a part of interpretation because the word may has been used in the first part of Order 6 Rule 17 of CPC. So it is giving wide and unfettered discretion to decide a case, and that can be done from case to case basis depending upon the facts and circumstances. The court may or may not allow the amendment of proceedings for determining the real questions of controversy. Second part is mandatory in that shall, and shall is used यानी कि mandatory provision है interpretation का, ordering the court to accept all the applications that are necessary for the purpose of determining the real issue between the parties. And if the court finds that the parties could not have raised the issue in spite of due diligence, then court can permit. So that is something which is a mandate on the court, that court has to consider this aspect. So in this way you can frame your answer in one flow and try to be very comprehensive and include all the important points over here. If you have any queries, you can reach out to us at iExamB, and also there is a free workshop session that is arranged at Legal B with Robin Dutt sir, who is having an experience of more than 25 years in practice. He is practicing at the Punjab and Haryana High Court and the Supreme Court of India. He is going to guide you all on the point of judiciary as a career, litigation as a career, ADA, how these booming fields are coming up after law. So if you have any queries, ये अपॉर्चुनिटी काफ़ी अच्छी है आपके लिए. आप इमीडिएटली जाकर डिस्क्रिप्शन में चेक करिए और इस वर्कशॉप के लिए रजिस्टर कर लीजिए. If you have any queries, you do reach out to us directly in the comment section also of this video. Don't forget to subscribe to our YouTube channel and prepare 50% faster with iExamB. Thank you so much.